And today I'm talking about the fact that the Constitution means what the Constitution means, even when the federal court system gets it wrong, which has been a lot over the years, especially since the New Deal era. For this discussion, I want to go back to Lysander Spooner's great 1850 pamphlet, A Defense for Fugitive Slaves, which I've covered on a bunch of other episodes, but not specifically on the judiciary. So I want to talk about his views about judicial opinions versus law, and the supremacy of the Constitution, and I want to kind of intersperse and compare some of his views with that of the founders for each section. And to start out, I'm going to link to this in the show notes at 10thamendmentcenter.com/path to liberty, but here's Spooner. He says, if a judicial decision contrary to the Constitution were binding simply because it were a judicial decision, the judiciary could make themselves absolute sovereigns at once. So the view is, well, there's something other than the opinion of these unelected, unaccountable, politically connected, lifetime appointed lawyers that are on the federal court system. There's something higher than them. Otherwise, sovereignty in the American system, we know, is final authority, and that would mean if it's up to the judges, if the judges get to say what everything means in their own view, and then that can change over time, then the judges hold sovereignty or final authority instead of what the founding generation said was the people. And I've covered this in a bunch of episodes, but here's just a few examples. Robert Livingston, the chancellor in the New York Ratifying Convention, reminded us that all power is derived from the people. All power is derived from the people. Or James Wilson, a speech in the Pennsylvania Ratifying Convention. He said, the truth is that in our governments, the supreme, absolute, and uncontrollable power remains in the people. And I can't remember if he actually highlighted, if it was highlighted remains in the original or not, but if you're watching on video, you can see that in the image that we created with that quote, we highlighted remains because Wilson was pointing something out, that it wasn't the documents that were giving final authority to the people. The people always had it. And then they were just creating a system under these various governments, the state and the new proposed federal constitution. So the truth is, James Wilson said that the supreme, absolute, and uncontrollable power remains in the people. He said, as our constitutions are superior to our legislatures, so the people are superior to our Constitution. So the view of the Constitution means what the Constitution means, what the federal courts say it means until the federal courts change their minds, means that it's not Constitution superior to legislature and people superior to constitutions. Maybe it's Constitution superior to legislature, people superior to Constitution, and judges superior to them all. And Spooner flat out rejects that right off the bat. Again, if a judicial decision contrary to the Constitution were binding simply because it was their decision, then the judiciary would be making themselves absolute sovereigns. Now back to Spooner. He said, there is not a syllable in the Constitution that makes a decision of the judiciary of its own force and without regard to its correctness, binding upon any body, either upon the executive or the people. And this is talking about supremacy. Again, we're talking about the supremacy. Who's at the top of the food chain? And what he's saying is the Constitution is the supreme law. It's not just the opinions of these judges. Here's how William Davey put it in the North Carolina Ratifying Convention. I'm primarily citing Federalists because these were the big government people of the time during the ratification, and many of their views kind of coincided with what Spooner was talking about. And as you read through the paper, he certainly cites quite a bit from the ratification debates. The man was pretty well read, even if you disagree with some of his approaches. But this is interesting stuff. Here's William Davey. The federal government, these acts of the federal government, and of course that counts all the branches of the federal government, can be supreme only in cases with the powers specifically granted and not in usurpations. And a usurpation of power is an exercise of power not delegated. And so if the judiciary sanctions that power, that sanctions a usurpation of power, then the judiciary is supporting a usurpation, and then it's no longer supreme. And that should be pretty straightforward stuff. Unfortunately, it's totally opposite today. James Madison addressed this as well in his famous report of 1800 explaining the Virginia resolutions of 1798 against the Hated Alien and Sedition Acts, he pointed out that, well, you can't just rely on the courts to get things done because, in Madison's words, dangerous powers not delegated may not only be usurped and executed by the other departments, but the judicial department also. Back to Spooner, he said, in the very nature of things, nothing but the law can be binding upon anyone. If a judicial decision be according to the law, it is binding. If not, not. And of course, we're going with the flow that the supreme law of the land is the Constitution itself. So if only the supreme law can be binding, a judicial decision in line with it is binding. If not, not, according to Spooner. And even Chief Justice John Marshall, if you don't always find a lot that you love from the guy, but here he is, pretty straightforward. I think this was 1824. He said, courts are the mere instruments of the law and can will nothing. Or Thomas Paine, he reminded us, said, so this was in Common Sense in 1776. So far as we approve of monarchy, because we know that Common Sense was an aggressive attack on the institution of a hereditary monarch, he said, so far as we approve of monarchy, in America, the law is king. For as in absolute governments, the king is law, so in free countries, the law ought to be king, and there ought to be no other. As I mentioned right at the beginning, I said I was going to link to all this stuff in the show notes over at 10thamendmentcenter.com/path to liberty. You really want to read through. It's not a super long pamphlet, A Defense for Fugitive Slaves by Lysander Spooner. I know a lot of people like to post some quotes from him from time to time. I do that as well. We do over at 10th Amendment Center social media channels. But this is actually probably my favorite thing that he wrote. There's so much great strategy and foundational principles in it. Again, A Defense for Fugitive Slaves. I publish a blog post for each episode about 1 to 2 hours after the live stream is done. And there you're going to find, well, this as you scroll through, you get all the different latest episodes. And there's always a section not only for all the different platforms we're on. Of course, we have all the mainstream live stream platforms. We also live stream at Odyssey and Rumble, Twitter and LinkedIn, plus YouTube, Facebook, etc. We also archive the video as many platforms as possible. We have the podcast edition, but you'll also find a show links section so you can be like, dude, you mentioned this thing, and I can't seem to find it. We'll include links in that blog post. Again, about 1 to 2 hours after the live stream is done. And while I'm doing that, I want to say a quick hello to everyone in the live chat. I really appreciate you guys spending some time with me today, and I hope you had a good weekend. There's Haji in Southeast Michigan, Tim Martin's in Arizona, Dixie Strong in Bama, Rivco Fireman, Alt Reality, Richard Banks, Natural Law, Larry Clark, Shinobi Tengu. That's awesome. Lawrence Smith, Senator DT, King Nobody, M. Gabriel, and everyone else. I know I'm skipping over a few people, but again, thank you so much for being here. I will take a look over the live chat later today or tomorrow and see if there's any comments or questions I can get back to. I get a lot of great ideas for future episodes too, so thank you so much for engaging. Anyways, let's go back to Spooner. Here he says, an unconstitutional judicial decision is no more binding than an unconstitutional legislative enactment. So, unconstitutional... He was pretty straightforward. He's like, there isn't kind of constitutional and maybe really bad constitutional. It is either constitutional or not. And if it's unconstitutional, they're not authorized to do it. The founding generation, and I've covered on this show so many times, referred to acts beyond the limits of the Constitution as usurpations, as void. Even Hamilton himself said, and then they deserve to be treated as such. So an unconstitutional judicial decision, wrote Spooner, is no more binding than an unconstitutional legislative enactment. And a man has the same right to resist by force as one as the other, and to be tried for such resistance by a jury who judge of the law for themselves. Of course, this is in context here, talking about resistance to the Federal Fugitive Slave Acts, 1793 and 1850, which he thought were absolutely abhorrent to all the principles of what was supposed to be a free society, but he was saying certainly not. So he's saying, look, this is unconstitutional. He's making the argument, urging people to resist those acts, and then urging jury nullification as a response to help protect them. And there's a whole section on that. I just sent it over to Mike Meharry, to possibly do an article, because I've covered Spooner's trial by jury paper, which is just... Pretty awesome stuff as well. But he has a nice section here about the impacts of jury nullification, encouraging people when you have a society that's willing to acquit despite the fact that the law says that the case says the law was violated. They're judging both the facts of the case and the law itself. You have a pretty good approach, and he's encouraging that as well here. But that's kind of a quick side note. He's saying, you have a right of resistance. And that's what the founding generation expected from the people, because that's what they lived through under the revolution, that great revolution in thought that led to the war for independence against the largest government in history, the largest empire in history. We can go back to Patrick Henry's response to the Stamp Act in 1765, where he said, look, this is a line in the sand. You guys aren't authorized to do this kind of tax. And therefore, we're not bound to yield obedience to those acts. John Dickinson told us that it was essential to refuse to cooperate with the Stamp Act as well, because compliance is what establishes what he called the detestable precedent. If you comply with the government, you can't comply your way out from under tyranny. That's kind of the short version of saying it today. And then here, even during the ratification debates, James Iredell, who ended up being on the Supreme Court, nominated by George Washington, here in North Carolina, he said the people will resist if the government usurp powers not delegated to it. Now, they haven't done that so much. Certainly he was correct in the short term, but after not getting as much success as maybe some of those people wanted, the mentality went away. But early on, the understanding was when government did stuff it wasn't authorized to do, that people would resist. Various approaches to that. It would be different in each situation, in each area by different people, but that's how you keep a government in check. And I did another episode that I should have had to pull up on the screen here as well, or at least in the show notes, Spooner's strategy to stop usurpation, which is also highlighting his approach to the defense of fugitive slaves, talking about resistance. Resistance to government overreach is how Spooner said you keep the government in check. And that's the same thing that the founding generation was telling us during the ratification debates as well. Here's Theophilus Parsons, Federalist supporter of the Constitution, lawyer, big government guy, to some degree at least, in Massachusetts. He said an act of usurpation is not obligatory. It is not law. And any man may be justified in his resistance. Not too much different than what Spooner was saying in 1850. A man has the same right to resist by force, one or the other, and to be tried for such resistance by a jury. So as soon as they go beyond the limits of the Constitution, you have a right to resist them. Now, that doesn't mean it's always every approach means stick your neck out, but the right is there, and we know that's how you keep government in check. So it's about coordinating a response to them as well. And here again from Spooner, he said the idea so constantly asserted that the permanent judiciary, the judges, have a right to decide all constitutional questions authoritatively for the people is one of those gross impostures by which men have always been defrauded of their rights. Now, people, of course, want you to believe that the Constitution essentially means, like I was saying earlier, what the federal courts say it means until they change their minds. And here's Spooner directly addressing this. The Constitution means what the Constitution means, despite what the federal courts happen to say about it, despite what the politicians happen to say about it, and really despite what any of us happen to say about it. It's just a matter of finding that consensus. So this is a gross imposture, the idea that this permanent set of judges have a right to decide all constitutional questions authoritatively. Thomas Jefferson had a little something to say about this as well in a letter to William Charles Jarvis, I think, in 1820. He said, "You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy." So Jefferson to Spooner, you're seeing a very similar mentality. The idea that if you leave everything in the hands of the judiciary then is above everyone else, unelected, unaccountable bureaucrats. It's an oligarchy. And Jefferson was absolutely correct. Spooner didn't use that term that I'm aware of, but it really is the same thing. And here he goes again. "The permanent officers of this department, the judges, so-called," this is Spooner again, "by the very constitution of their office, are unfit to be trusted with any question arising between the government and the people as to the powers of the former and the liberties of the latter. For the judges receive their offices directly from those other departments of the government and not from the people. So he's saying, well, they don't technically work for the people. You can't even, I know there's going to be debates about, well, government doesn't really work for us. That's pretty obvious. And you can't have real representation, especially with the numbers that they're talking about. That's a different discussion. But he's pointing out that if you're going to a legal debate between government and the people who make the decision on who's right and wrong work for the one side, this is not an equitable situation. My friend Tom Woods used to always make a description about this when he did speeches at our nullification tour events years ago. He would say, like, okay, think of it this way. The government, the judiciary works for the federal government. The federal government is the problem that we're trying to address. Relying on part of the government isn't going to help. So he would say things like, well, imagine you and I had a problem in court and we decided to hire as an arbiter my mother. Now, my mother doesn't always agree with me, but in the end, it's probably pretty likely that she's going to take my side. That makes a lot of sense to a lot of people. Now, some it doesn't, but because they are going to say, well, the judiciary is independent. But Spooner is just pointing out, look, these people are nominated and approved by the people that are being challenged in the court case. And if you can rely on that to be an equitable situation, you're in big trouble. They are also dependent upon all these other departments for their salaries and are amenable to them by impeachment. They are, of course, nothing but instruments in their hands and have always proved themselves to be so. He then goes into this long rant about how he saw the court system as of 1850 as being a rubber stamp. I often cite the 1930s or so, the FDR era, the New Deal era, as a great expansion of power of the judiciary, but certainly Madison was concerned about it in 1800. Jefferson was warning about it in the 1810s, 1820s, in a series of letters, probably a lot from Marbury versus Madison, some of the John Marshall opinions throughout that time. And then Spooner was basically saying, I can't even think of a situation where they didn't side with the government. How can we rely on this? So, of course, Jefferson had a little something to say about this as well. And here he is in the Kentucky resolutions of 1798, also against the hated Alien and Sedition Acts passed on November 10th that year. He said the government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its power. So Jefferson is taking the same position, or Spooner is taking the same position as Jefferson. The Constitution is the supreme law of the land, and relying on the government to determine the extent of the powers of the government itself, whether it's one part of the government or all three branches, ultimately you shouldn't be surprised when that power grows and grows and grows, no matter which team is in charge. And he was very much concerned about this, and Spooner was addressing that as well. And I think Spooner really wraps up his view on this so well in this phrase. It's a kind of a long section here, but let me just go through it and hopefully it makes sense. He said, a judicial decision as such has therefore no intrinsic authority at all. Its constitutional authority rests wholly upon its being in accordance with the Constitution. And I think that goes so well with the title of this episode, Opinion Not Law, Spooner on the power of the federal judiciary. They're issuing opinions. If their opinions happen to be in line with the Constitution and then the people agree with that, then that's okay. Now, if their opinions are not in line with the Constitution and the people agree with that, it's not okay. Well, I mean, maybe it's okay to the people. They're fine being on their knees demanding more power in the central government or violations of their rights, and that's what we've seen so much of over the last bunch of generations for quite some time. But ultimately, when it comes to the Constitution, as Samuel Adams and James Otis Jr. said in 1767, in all free states, the Constitution is fixed. Not that it can't be changed, but its legal meaning is the same. The meaning of the Constitution remains the same no matter what the courts, the politicians, the government, the people, whatever they have to say. Words mean what words mean. And we know that they like to change. Orwell, of course, warmed us up for what we face on that. They like to change the meaning of words in order to give themselves more power. And of course, we know that John Marshall certainly did that very early on, adopting Hamilton's meaning of the word necessary, whereas Necessary in the necessary and proper clause didn't mean necessary. It suddenly meant convenient to the power of government. Anyways, a judicial decision, Spooner makes clear, has no intrinsic authority. It only rests on whether it's good or not upon being in accordance with the Constitution. And we can determine whether it be in accordance with the Constitution only by first determining the meaning of the Constitution independently of the decision and then comparing the decision with it. If we take the decision as authority for the meaning of the Constitution, all decisions will of necessity be constitutional, and the judges are, of course, constitutionally speaking, absolute despots. And really, in practice, even when they do the right thing, in essence, that's kind of how the people have allowed things to play out in modern times. They basically say, hey, federal court system, tell us we can be free. Instead of learning how to exercise our rights, whether the courts, whether the federal government, whether any government wants to allow them or not, most people tend to take a position of, well, let's wait for the federal courts to sanction this. And maybe every few decades they'll overturn some power, while in the meantime, they're rubber stamping more and more of it all along, or supporting twisted versions of the commerce and necessary and proper clause, or turning down cases, whatever it may be. But as long as people are not exercising their rights without first waiting for government, this is not a land of the free. It's a population on its knees begging for permission. Well, I hope you guys found this interesting. I hope it was educational. I hope it was thought-provoking. More than anything, I hope you learned something. If you want to help us get this information out to more people, nothing helps us get that job done more than the financial faith and support of our members. We can reach and teach people about the Constitution and liberty and how to defend both, whether the government wants us to or not, which is, well, that's not an easy thing, but we got to build that foundation, person by person, state by state, brick by brick, a strong foundation for liberty for the future. And so our memberships start out at just $2 a month. We also have annual, 5-year, and lifetime options. I also want to take a quick moment to say thank you to just a handful of people who have joined us as members recently. I really, really appreciate your support. And I know I'm missing a few people here, but there's Gregory in Florida, Lee and Sherry in Tennessee, Joanna in New York, Amiro in Florida. I apologize if I get the name wrong. And Tom in New Hampshire. Again, thank you so much. If you guys want to join them as well, it's 10thamendmentcenter.com/members. Let me take a look and see if there's any comments or questions I can get back to for the next minute or two before I get through here. I saw some blurb about the SPLC considers Michael and the 10th Amendment Center as extremists. That's Run Level 1. Yeah, they did a whole feature on me in their Hate Watch as one of the leaders of the new radical right, part of Hate Watch. Of course, they tied me in with a bunch of other really crazy, well, I don't know, whatever. But I think Run Level 1 makes a good point. At first, I was offended by it. I'm like, are you kidding me? But then really I thought about it over time. If they're attacking, you don't catch flack unless you're over the target. And these people aren't being honest. What they really are doing is they're using maybe a storied tradition that they had as a way to kind of attack people who don't like government power. So as long as you're opposed to centralization of power, they just go after you. And Run Level 1 says, that's a stamp of approval as far as I'm concerned. That's the way I look at it as well. Thanks so much. Haji says Spirit of 98. Of course, that's what we're talking about when we're mentioning Jefferson and Madison and the Kentucky and Virginia resolutions of that year, and then Madison's report of 1800 as well. Run Level 1 also says the judiciary is the HR department for the government. Yeah, I'm not sure. They're supposed to be, they're just human beings, and they've been placed in a position of power. And as long as the people allow them to have more power than they're supposed to have, they're going to continue expanding that power. And just a quick aside, between allowing the part of the government to be the final arbiter of the extent of government powers should be bad enough in and of itself, like Jefferson told us, or like Spooner was saying. That in and of itself is putting them above all of us. They have sovereignty or final authority. Then on top of it, when you look at the incorporation doctrine and all the power that they've basically assumed since 1925 or so, it gets even worse. Let's take a look. Haji says it's also a badge of honor. Frankie Diaz, love you guys. Back at you as well. how to donate from Puerto Rico. You should be able to over at 10thamendmentcenter.com/donate if you want to just do a one-time donation as well. MRGF78 says, I'll share your videos. Thank you so much. I'll scroll through these comments a little bit later today or sometime tomorrow, but I'm going to head out about now. I hope you appreciate the episode. I appreciate you spending some time with me today. I hope you're having a good start to your week. Again, 10thamendmentcenter.com/members, 10thamendmentcenter.com/path to liberty is where to follow us. And I hope to see you next time here on the Path to Liberty.